Hi everyone, and today I'm very glad and very happy to introduce you to our guest speaker, and it is Linda Sprukste. She is really expertised in business and IT law. She is a lawyer, and today's episode or video will be for B2B marketers and marketing experts about AI regulation, data compliance, everything, what impacts our work, what are the risks, and following 2026 year, we should be prepared for that regulations and new rules which we have to take into account in our daily work and how it will be impacted, what are the risks and how to get prepared for that. And that's why I'm happy to introduce to Linda and thank her for her time joining us today. So I will give the floor or stage for you. So please continue.
Yes, thank you, and hello everyone. Yes, I will start with some small explanation about European Union I Act, which is Artificial Intelligence Act. And the use of artificial intelligence in the IT world has been very topical and discussed for some time now, and the topic of legal regulation has also become relevant. And since 1st of August 2024, the European Union entered into force regulation European Union 2024-1689 of the European Parliament of the Council, also known as Artificial Intelligence Act, and which is the world's first piece of legislation on artificial intelligence, which could be in the future becoming a global standard for AI regulation and as similar as GDPR Act now. And the aim of the AI Act is to ensure that artificial intelligence systems are safe, ethical, and trustworthy, and are developed and used responsibly. And the AI Act is planned to be implemented gradually until 2nd of August 2027, which certain expectations for entry into force. The Artificial Intelligence Act will apply at different levels to the developers for AI tools, users, distributors, and other groups of persons involved in the development and delivery of artificial intelligence, and also regulates the authorization of AI systems in the European Union single market. As foreseen by the Artificial Intelligence Act, the extent of the requirements imposed on companies will depend on the risks posed by the AI system used, which are divided into 4 risk levels, and which with different rules developed accordingly. The risk levels are minimal or no risk, limited risk, high risk, and unacceptable risk. And AI systems that pose only limited risk will be able to use subject to information and transparency obligations. For example, it will be necessary to indicate that the content was created by AI so that users can make an informed decision about their future use of their content. It means they can decline or continue to watch, for example. This new Artificial Intelligence Act, European Union has made also some special regulation committee and also a register for high-risk AI systems, and I will very soon I also will tell you about some penalties and so, but yeah, there is a lot of rules, regulations, and also every country should implement the act accordingly, and yeah, that is a really complex document actually, and it's hard to simplify it and all the information in it. So, but I will try my best.
Okay.
Yes, and we had a question. Yes, what should marketing professionals, especially in B2B, know about AI generated content and compliance in 2026?
Yes.
And then I try to make some points which are maybe from my opinion important, and 2026 B2B marketing professionals should navigate the evolving regulatory landscape surrounding AI generated content, particularly with the European Union's AI Act setting standards for transparency and accountability, which is really important right now as well. And second, maybe could be compliance with stricter data protection laws, such as GDPR and CCPA, Canada Act, and is essential, requiring transparency in data collection and use. That's also really important. And then there is ethical considerations, which will be crucial as marketers need to avoid bias and ensure AI content is inclusive and fair. And verification of sources is necessary to maintain credibility and avoid misinformation. That is, to be clear, disclosure of AI generated content will be strengthen audience trust and comply with potential regulations. So, as I mentioned before, that all materials which are created with AI technologies should be written down so that there is some AI involved in material. And understanding the legal implementations of creative ownership and copyright will become increasingly important as AI tools evolve. And maybe some final point would be a balance between AI efficiency and human creativity, which is vital for producing high quality and authentic content. Because with AI technology involved, we also should remember real people and real human work. So that should not be forgotten. That there is also some real copyrights and intellectual property involved.
Yeah. My question as well was that if we produce that content, then the tricky part is who can distinguish that, whether it's original and created by human, or it's created by AI or with involvement with AI, and who will check that all information? Do you think that each country will adapt who will be responsible for that kind of checking, or maybe society will have a chance to report, or how it will be? Who can decide that? Even AI can distinguish.
Yes, that is, of course, in the first place, it's hard to say everything, but every country should should make implementations in their rules, as well as some organizations. For example, in Latvia, there is already Varam and Tiesībsargs, which will be responsible for all these regulation rule regulations,
Okay.
authorization, and also society. If one person sees that there is not written something, and he is quite sure that it's made by AI technologies, so he could
Report it.
report, yes, he could report this to TSIPSERX or some other organization, or even to your European AI Council, that there has been some misleading information. And afterwards, of course, there could be penalty or some warnings, and that could be quite serious, actually, because it depends on companies' year's salary percentage, so it can be quite high, actually. Maybe there was some systems also which were manipulating people's sounds and their
using their voices. I have heard that there are
personal
scams.
voices. Yes, voices scams, like some video materials where person speaks some crucial information, and even in high society, even in governmental level. So that is really unacceptable for European Union level. So that kind of systems are forbidden.
Okay.
Yeah, that's also something I found interesting, and in fact, I feel a little bit more safe in that way, maybe. Yeah, because we also have seen, I have seen some videos which are really hard to say if it is a real person or if it's not. So sound is the same, and if something like that happens in governmental level, it could be really big impact afterward. So yeah.
Yeah, we can imagine.
Yeah, we can only imagine, and I'm glad that European Union has stepped some ground rules about it.
Okay.
Yes, and
do we have anything else about AI, or we are proceeding in data compliance topic?
I have actually about legal risks.
Okay, yeah, that's.
Yeah, I have some points about legal risks. What should companies consider when integrating AI tools into their daily marketing process?
Okay.
And for example, companies using AI tools must ensure compliance with data privacy laws like GDPR and CCPA, Canada Act, to avoid fines and associated with improper data handling. They should clarify intellectual property ownership concerning AI generated outputs and ensure no copyright materials are used without proper licensing. And misleading AI generated content could expose companies to claim of false advertising or deceptive marketing practices. And transparency is crucial. Failing to disclose the use of AI can lead to consumer distrust and regulatory scrutiny. Yeah, which is really, really hard point when company have this scrutiny. And yeah, I hope no one will make until that point.
Okay.
Yeah, because I think that is the least wanted thing.
Mm-hmm.
Therefore, companies should make some preparations before they use AI tools in their daily lives. I think right now it's crucial. And the next maybe is when partnering with AI service providers, companies must review contracts to mitigate liability regarding data usage and legal infringements. That is also important to make sure both sides in contracts knows what they are expecting and what they will receive. So yeah, it's also future must-haves in legal contracts, and companies should also address security risks, as AI tools can be targets for cyber attacks, potentially leading to data breaches. That's also really important, because if AI tools learn some privacy data, there should be also strict rules how they give that data or don't give, I hope so, to third parties. So it's also really, really important. And according to Artificial Intelligence Act, Chapter 12, there is out quite amount of fines, which are based on a percentage of the company's total turnover in the previous year, or a fixed amount, whichever is higher. I already mentioned a little bit of that. Yes, and that is also really, really crucial to remember, that fines are quite high. Yes, and one thing what is interesting comparing with GDPR, that proportions of fines are applied to small and medium companies and startups, which are a little bit more less than maybe bigger companies, which is interesting. Also, maybe comparing with GDPR, they have come to sense maybe that small companies, maybe they also, AI technology is quite modern and quite new, and this AI Act also supports new and science creativity. So therefore, maybe also because some new companies try to make some good things too, and maybe they use AI tools to make something new. Even nobody knows right now, and that is something.
We all are still learning everything about this new technologies, right?
Yes, right. And also science, for science usage, there has AI Act have some separate rules. They a little bit more allows to make some exceptions, but they these companies should make some special rules and some special things for science field to make sure AI tools are used only for science and according to AI best practices. How can companies prepare for the future by revising consent practices, and especially in the context of cookieless environment? Because that's also one field which is quite hot right now.
It is.
Because all cookie and environment and data which companies uses for marketing process are quite important for them, but maybe some people don't like to give that cookie
Exactly.
data.
Yeah. Yes.
And therefore also companies should give opportunity for people to choose which data collect, which not, and cookie policy should give at least 3 options. Choose which data to give or not to give, don't give anything, or give all data. And yeah, that's also important to remember. And yeah, as a company's transition to cookieless environments, revising consent practices is essential for effective data collection and compliance. And implementing a user-friendly consent management platform can simplify obtaining and managing user consent while ensuring regulatory compliance that I mentioned. That is important, yeah, that everyone can see which data they give and what company are using and for what.
And does it mean that we have to, sorry, yeah, does it mean that we have to make new, better explanations in these descriptions, or only just it's okay when we show that well-known pop-up bar to show these 3 options?
Actually, there is quite some differences between those plugins, because some of them are just how to say, some of them are fake, like they are only showing something, but some of them are real, which really are automated, and they how to say, for my experience and my company's experience, I can say we really made some research about this. I personally also looked through these plugins, and there is some which really make some lists for each and every one cookie, and they also make how to say, make some also different kind of cookie lists, for example, which is necessary, which are not so necessary for marketing, and there is also some things which are important for web system to work as well, we know, but some are just temporarily or not so necessary. And there is special in this plugin, when you push the button choose, you can also really push the button which ones you don't want to allow and which will you allow it for this web page to use, actually. And it really works that way. And we have also checked this, especially this function that is really the same as they say it is, and it works.
Yeah,
And
I have
therefore,
heard this. Yes, I have heard this. That the one thing they show, it's like a decoration, but that actually data have already like flowed into. So it means that marketers should consult IT department or ask to check about the plugins as well, if they truly work as they should.
Yes, I recommend it, actually, because IT specialist can tell you if it is really working or it's not really working. So yeah, it's interesting, but we can check it and we can tell you if it's working or not working. And yes, and about investigating in contextual advertising can replace third-party cookies by focusing on content relevance without user tracking. That's also important because third-party plugins or some third-party cookies also can be switched off or left as it is. That's important to, and also what one point is also really important to make sure that information includes also in privacy policy or in cookies policy. So
Okay.
to inform users for which cookies or which information they use, to make sure all is transparent for users.
Okay.
Yes, and what I would recommend that regularly updating privacy policies and educating customers about data privacy changes will enhance trust and compliance as well. And also companies also should educate their employees to make sure they also know what they are doing, because it's not enough only for some people, especially in IT field. We should try to educate all new members, all new IT specialists and programmers as well, to make sure all safe data is used properly, and everything should be also discussed in daily life. So, and companies should continuously monitor regulatory changes and seek feedback to refine consent approaches as well. And by adopting these strategies, business can thrive in cookieless environments while respecting user privacy and maintaining effective marketing practices. Yeah, that I think is really important, to make sure we respect our users' privacy as well.
Okay, but if the user, for example, if I include the rules that when a user accepts all, that he or she accepts all those cookie information, I can include that they are, for example, confirming that they will be included in retargeting, for example, campaign. So they will have they will give their data, and I can run those remarketing campaigns.
If they are like, if they have given permission for that, yes, and there is also rights to write to company and say that you don't want to unsubscribe. For example, you everyone should be able to unsubscribe that. So
Okay.
in the future also, not only one time, but for example, if you accept to receive some emails or some marketing materials, you should be able afterwards also unsubscribe for it. So there should be some chances. That's also, that's according to GDPR's rules as well. Yeah. And there is also some one question about are there significant regional differences between European Union or
US.
US that marketing teams should be aware of? Yes, there is. And there is some significant regional differences between the European Union and US that marketing teams need to consider regarding data privacy, regulations, and consumer attitudes. And for example, European Union GDPR enforces strict data privacy standards that require explicit consent for data collection, while US laws are more fragmented and less stringent, varying by state without a unified federal framework. Which I mentioned, yes, there is more in every federal state. There is their own rules by which they are led. So in the European Union, there is more strict rule. Yes,
like common
and,
rules. Yes, we have at
common
least we
rules
have
for
common.
yes, for all the countries in the European Union. Yes.
Okay.
And in the European Union, obtaining explicit consent and providing clear information about data usage is crucial, whereas the US allows for more flexible consent practices and often relying on top-out mechanisms. And direct marketing in the European Union is regulated under GDPR, requiring consent before communications, while the US follows the Can-Spam Act, which mandates opt-out options, but with more leniency, so it's more flexible as it is in the European Union, as we can see. And European consumers are generally more aware of privacy rights and critical of data practices, while many US consumers are open to share data for personal experiences. And marketing strategies in the European Union must be localized to accommodate diverse languages and cultures, whereas US strategies can be more standardized. So it's also difference because we have cultural differences in European Union as well. And there is more, some countries are more open for new things and some are not so open as well. And regulatory focus in the European Union prioritizes consumer protection and ethical marketing, while the US emphasizes innovation and business interests. Also, this is changing.
Okay.
Yeah.
Interesting difference in approach, right?
Yes, that's also really interesting. Although I think European Union, there was last year, I remember there was some discussions about how open European Union is about some innovations and all, and in a way this IE Act actually maybe will help to make some visions in the future, because they, with GDPR, there was feeling that all should be controlled, but with this IE Act, actually, they gave some chances in science. In this way, they opened up a little bit, but not too much. As we know, European Union is quite conservative. Yeah. And what else I could say, that enforcement of GDPR are violations in the European Union can result in substantial fines, unlike the often lower penalties under US state laws. That's also that we have higher fines than US. And understanding these differences is essential for creating effective and compliant marketing strategies that resonate with audiences while also adhering to local regulations. That's also for regulations and differences between European Union and US. But I have in mind right now.
Yeah. Thank you. That's very interesting. And regarding European Union, even through jurisdictions, there are differences in these data compliance as well. So that's interesting when you small market like Latvia. I always say that I see these Baltic states as a one market, and even then, in those small countries, there are differences in these data compliances, and we have to take into account each country's jurisdiction when we communicate in marketing, right?
Yes, right. And also for different countries, there could be different marketing campaign differences. So it's also, as I mentioned, there is some cultural differences as well. What will work, for example, in Scandinavia, maybe will not work in some maybe Spain or Italy.
Of course, yeah.
Greece. So that's also important to remember. Yes, we have some differences.
Okay. Summarizing all this huge information which we have to take into account, where do you see the biggest maybe risk or risks into next year upcoming? Or maybe two things we should definitely, as a marketers, take into account and maybe take real action?
Yes, what I suggest that first one would be, if choosing IE, to create some new materials, some marketing campaigns, to remember to write down that there has been involved IE system. That is one important thing as well. And the second would be, I think, to remember to respect copyrights and intellectual property.
Okay.
That is, I think, for my opinion, could be important to remember.
Maybe the biggest or more, not the biggest, but maybe more popular breach, maybe what we are experiencing, those copyrights, right?
Yeah, because that is something, I think more copywriters and more marketing people, maybe especially influencers maybe, and real persons which are involved in some video materials will be more interested. And also I think we are pushed to write down that we are using some IE tools, but maybe there is good to write down also that this material has made with real people and real persons material. Maybe we also could write that down.
Cherish the creative work. You mean cherish the creative work?
Yes.
Okay,
Yes.
that's so nice. That's nice. Yes, I agree with you that that we should cherish nowadays this originality and creativeness and artistic approach. It's more unique nowadays, right?
Yes.
Mhm. Thank you. Thank you so much for your time, for all the important information. I think that's really valuable for all the marketing persons in companies. And I guess this new year already we can start to adapt for these new rules. So we are ready and fully uh, with those new, maybe new approaches and already ready for this in August. So we don't wait the last minute to be ready, but we adapt and use these habits, make it as a habit, this new best practices.
Yes. Why wait? I
Yes.
really suggest to do it now and practice now. So we are already in the future.
Thank you. Thank you so much, Linda, for your time. And really, I really appreciate your valuable input and hope that we will see you in some future as well. In some, because this part as a marketers, we have to stay updated in so many fields, and all these regulations and legal matters really matter in our work, and that's the good approach to stay updated and avoid penalties or any kind of problems now and in the future. So thank you very
Yes.
much. Thank you.
Thank you to you too. And I hope this information will be valuable for everyone.